we are going to now spend some time on the mains part of judiciary. That's our agenda for today. Somebody was asking for my comments on the Karnataka issue. Let the issue entirely unfold. Let it all get done with. Then we will, get into the details. But it's not something which is exam relevant as such anyway. All right. Good morning, ladies and gentlemen, boys and girls. Good morning. We're going to now study the mains related portions, the layer 2 of the judicial system. Bear in mind that we've already covered judicial review and judicial activism and related concepts in the sense that we've already covered how it's an extension of separation of powers and so on and so forth. Now, let's spend some time here. So, one of the first things that we must understand is where there is a question of independence of judiciary. See, when we say the judiciary is independent and integrated, my health is all right, don't worry. All right. Anyways, so when we use the word integrated, we understand how from the lowest court of the country, you have the right of an appeal to the highest court of the country in a sequential process, in a gradual process. We understand that the judgments of higher courts are binding on lower courts. We also understand that the system of judiciary in the country has a uniform appointment, at least in the sense of the higher judiciary. And these are the reasons why India is an integrated judicial setup. What is in fact a matter of grave concern and must be addressed with immediate effect is how independent is the judiciary. Now, bear in mind that India has a self-appointed judiciary. Now, a self-appointed judiciary is technically supposed to be relatively more independent than other forms of appointments where the executive, or in a presidential format, the head of the state, who's the president, is the one who finally takes a call. In India, the government plays a supportive role in the appointment of higher judges. We're not referring to lower judiciary because at this moment, lower judiciary is recruited by the state governments through a written exam, and the interview panels for which are comprising of the respective high court judges. Now, see, the context to independence of judiciary originates from separation of powers. There are three main branches of the state, namely the legislature, the executive, and the judiciary. And all of them have been given very distinctive functions to begin with, and in such a way that their functions don't transgress into each other's arenas, into each other's boundaries. And therefore, each branch of the government, each state of the government is autonomous and sort of self-sufficient in its own way. Now, it also means that the courts of the country are not particularly answerable to any other branch of government. Of course, in matters of grave concern, it is the legislature who removes the judges, and those are extraordinary circumstances. But in terms of the judgments that they make, in terms of the interpretations that they are allowing, in terms of what they declare to be constitutionally valid and invalid, these are things that they do completely on their own. Now, this makes the judiciary an independent and unbiased authority in the process of adjudication. Adjudication is basically deciding between disputes or deciding a matter which is contested. And there is, of course, a relatively higher degree of freedom in the appointment of the members of higher judiciary. Now, in India, as I have explained to you, the collegium decides on a name, sends the name to the president, on the advice of the council of ministers, and in the case of the state, the chief justice of the state and the governor of the state accepts the collegium. There have been situations in the past where the president has returned the collegium and have asked them to reconsider and send a name back. And because the president is under no hurry to formalize the appointment, this is a little bit of a gray area in the way things function. In fact, about 3 odd years ago, the collegium had recommended the elevation of a sitting judge of the Uttarakhand High Court to be elevated to the Supreme Court as a Supreme Court judge. But the president, under the current government, had returned the collegium recommendation of the Uttarakhand judge, and it was speculated in the newspapers that the reason that it happened was because the judge had struck down presidential rule in Uttarakhand, therefore creating a sense of a feud between the judge and the government. Now, have there been sort of instances where independence have been questioned? First is, we've of course gone through the Keswananda Bharti judgment, and we've also gone through the implications of the Keswananda Bharti judgment, wherein even through a minor sort of a majority, 7:6, by a very narrow finish, we were able to conceptualize the doctrine of basic structure. And that, of course, is one of its inherent criticisms, that it's not a unanimous judgment to begin with. But during the emergency, there were several judgments which, of course, were questionable in nature. First was, of course, with respect to the writ of habeas corpus, which was denied during the emergency, quoting that it was the emergency, which was a colossal lack of integrity from the court. And the court later on recognized it to be a mistake and rectified it. We also understood that during the emergency, one of the judges who had given a judgment against the basic structure had tried to set up a bench to review Keswananda Bharti, but due to circumstances, the bench was eventually dissolved within 2 days. Apart from this, of course, the government has, with the lack of a seniority principle in and around the same time, the government superseded 3 senior judges and made Justice A. N. Ray as the Chief Justice. He was in fact the same person who wanted to set up a review bench of the Keswananda Bharti case. Third, the Uttarakhand example that I was giving you was about Justice K. M. Joseph, whose recommendation was not accepted by the collegium initially. And then, of course, most recently, when we have seen Justice Ranjan Gogoi, who was appointed to the Rajya Sabha after several pro-government decisions, and more importantly, on an ethical and a moral issue where there were allegations of sexual harassment against Ranjan Gogoi. What was also colossally problematic was the fact that Ranjan Gogoi was also chairing the committee on which was investigating the issue of sexual harassment against Justice Ranjan Gogoi. Okay, so this is essentially what happened. This is the context. This is why we are studying about it in a larger frame of mind. Now, the first question should be, is independence of judiciary a part of basic structure? Now, the question is, why is this important? This is important because if you can make a law that changes the way judiciary appoints itself, which changes the way judiciary is able to deliver judgments, or is changing the jurisdiction of the judiciary in such a way, changing the powers of the courts in such a way that it is compromising their independence, then can you strike that law down? One of the most classic examples of this was, of course, the National Judicial Appointments Commission. Now, the National Judicial Appointments Commission, which was originally initiated through the 99th Constitutional Amendment, wanted to primarily replace the collegium system in India, where they wanted to set up what was called the National Judicial Appointments Commission. This commission would be chaired or headed by the Chief Justice of India, would have two other Supreme Court judges, would have the law minister, would also have two eminent jurists who would collectively be nominated by the Prime Minister, the Leader of Opposition, and the Chief Justice of India. These were the people who were to nominate the two eminent jurists. Now, what was the functional difference here? That the recommendations for appointment or transfer were entirely made by the judges in the collegium system, then of course were sent to the president for consideration. But here you of course had representations of the judiciary in the form of the Chief Justice of India and two Supreme Court judges. You also had a representation of the executive, and you had two eminent jurists who would collectively be representing the executive, the legislature, and the judiciary combined. Even in such a scenario, one could safely say that the judiciary had an upper hand and a higher composition in the National Judicial Appointments Commission. However, there was a provision in the National Judicial Appointments Commission that if any two members vetoed upon a recommendation of transfer or appointment of Supreme Court or High Court judges, then the recommendation would be eliminated, would be rendered infructuous, would be rendered as invalid. Now, that meant, from the point of the judiciary, a positive note that if two Supreme Court judges and the Chief Justice, either two of these three people said no to a recommendation, it was done. But what if even one out of these eminent jurists and the law minister vetoed on something, and let us say one of the eminent jurists was siding with the government at that point, then in one way, the legislature or the executive could hypothetically have the powers to veto a recommendation. Now, this means that even if the judicial side agreed to a recommendation, were backing a recommendation, theoretically it was possible that the legislature or the executive could override the recommendation of the judiciary within the whole commission process. This was of course challenged in the court. This amendment which was passed would of course be a constitutional amendment under Article 368, and would also require state ratification, as you were changing the appointment and removal of Supreme Court and High Court judges, and this is clearly mentioned in Article 368. Now, when I remember this case was being argued, it was argued during the summers where usually the Supreme Court is shut. So a special bench was set up, and you had representatives of all the states and of course the center arguing on one side, and of course you had the Advocates Association advocating the other side. They were the ones who had challenged this. Eventually, the judgment was that the Supreme Court struck down National Judicial Appointments Commission, and they said that this is not acceptable because it violates independence of judiciary, which is basic structure, and you cannot make a law which violates basic structure. So what's very interesting to note is basic structure has been conceptualized by the judiciary. Independence of judiciary was added to the basic structure by the judiciary, and it is the same judiciary who had declared NJAC as unconstitutional and basically completely nullified an entire constitutional amendment. As a recourse of demonstrating transparency, the Supreme Court later on declared that the minutes of the collegium process, whenever the meeting happens, and the outcome of the meeting will be published online, and everybody will be able to see what the discussions have been. So this was sort of a balancing act, a very poor balancing act if you ask me, but a balancing act nonetheless. But this is largely how it eventually sort of got through. Now, it was actually in the S.P. Gupta versus Union of India case of 1991, which is also popularly called the first judge's case. You may have heard of it in terms of the evolution of, the number of collegium members required and so on and so forth. These are too historic, they're never asked. There was a dedicated question on NJAC a while ago, as soon as the judgment was delivered. So both of these questions are not going to be asked. What was the first judge's case, the second judge's case, the third judge's case? You need to know what the current status is. You don't need to get into the historical review behind it. So as a result, it was in the very first judge's case where the judiciary declared that independence of judiciary was in fact a part of the Supreme Court, was a part of the basic structure, and this was again reiterated and reaffirmed by the court in the second judge's case called Advocates on Record versus Union of India in 1987. So you've got the first judge's case, the second judge's case, and third judge's case. Okay, now this is broadly what is needed. This is broadly that was required. You don't need anything else beyond this. Okay, now once we are sort of clear with this, once we are okay with this, we now move to the other elements. When we have already discussed the basics of appointment and removal, and often in the mains exam you get a question on this, I have given you some broad guidelines that you can be writing in your mains exam. Okay, the article numbers that I've quoted here need to be known. So judges of the Supreme Court and the High Court are appointed by the President of the country, Supreme Court judges under Article 124 Clause 2 and High Court judges under 217 Clause 1. I've already discussed with you that the Chief Justice of India is appointed by the President in consultation with the Supreme Court judges as well as the High Courts. However, as per convention, there is no written law on this. So if you ever get a question in the prelims exam that under the Constitution, the senior most judge of the Supreme Court has to be appointed as the Chief Justice of India, that in fact is an incorrect assumption to make. It's not in the Constitution. It is something which is derived as a matter of custom or convention, largely emanating after the debacle in terms of the appointment of judges in and around the emergency. So it's usually the senior most judge of the Supreme Court who is appointed as the Chief Justice of India. Similarly, the Chief Justice of India, of a High Court, is also appointed by the President in consultation with the Chief Justice of India and the Governor of the state. But in the High Courts too also, that the existing senior most judge of the High Court is appointed as the Chief Justice of that High Court. If you are, and it's usually with the number of years that you've already been a High Court judge, that's your primary indication of how senior you are. The process of appointment for judges, the process for appointment of judges of the Supreme Court was actually finally streamlined in the third judge's case of 1998. We've already spoken of the first and the second in the previous slide, which basically set up what is called a collegium process. And this collegium process consisted of 4 senior most Supreme Court judges, in addition to, of course, the Chief Justice of India. The collegium recommends these names to the president, we've discussed this, who then appoints the recommended persons as the judges of the Supreme Court. Now, the High Court judges are also appointed by the same way on the recommendations made by the collegium. Here you have a 4+1, here you have a 3+1 setup where you have 2 senior most judges of the Supreme Court, and then you have the Chief Justice of India. And apart from that, you also can consult the Chief Justice of the respective High Court. So broadly, this is the process. In case you get in the mains exam, you can either make a flowchart out of it or you can make specific points out of it. There's absolutely no problem with it whatsoever. And this is more than enough. All right. Now, let's get into the rest of our discussions. So, your qualifications and removals are here. A lot of your prelims questions often come from here. We've discussed this before. Supreme Court qualifications, High Court qualifications. I've also explained how the qualifications also overlap in terms of the 10 years here and the 10 years here, which means there is a similar qualification for you to become a Supreme Court or High Court judge. We've covered this before. And of course, we've done this as an example of a financial bill where we had increased the powers of we've increased the number of judges to the Supreme Court from 31 to 34. And I had told you that the strength of the Supreme Court is determined by the Parliament, whereas the strength of the High Court is actually determined by the President, right? We've done the removal process, wherein they're removed by impeachment through the process of the Parliament. And you can do that on 2 grounds, misbehavior and incapacity. We've done this day before yesterday. And you have a dedicated procedural law called the Judges Inquiry Act, which gives you how to go about it. And of course, this is done through a special majority, and that's special majority 2, which is more than 2/3 of present and voting, in such a way that it is half of the total strength of the House. Now, these are your basics of qualifications and removals. We've done this before, but in the mains exam, in case they ask you, you can always quickly write them up and carry on, because you often get very factual questions. Now, let's understand this in terms of what is the impact. This is the important part. You see, the current system of appointment of judges is primarily controlled by the judiciary itself. And we have to understand the impact of appointments and removals on the independence. And how are we making it a little too independent? Are we making it as independent as it is supposed to be, or no independent at all? Okay. Now, no, it says a High Court judge, lawyer has to be practicing at the High Court. I've explained to you also before. What is the need of consultation with High Court judges in the case of CGI? Because you might be also consulting the Supreme Court judges the judgments are binding all across the country. Anyways, the collegium system ensures, and this is the analysis part, the collegium system ensures that the members of the higher judiciary are directly involved in the appointment of the judges. And as far as this process is concerned, it is negligible or minimally interfering by the legislature or the executive. If we have to count the number of times that the recommendation of the collegium has been returned by the government through the president, it's not even 5% of the total recommendations that have been made. So that's for sure. It is the rarest of the rare scenario where the government really returns a recommendation, right? The recommendations are usually and customarily always accepted by the president, and that's how you maintain the independence of the judiciary. But under no circumstances does it say that the recommendation collegiums have to necessarily be accepted by the president. The president is not bound to accept the recommendations of the collegium, because if that would be the case, then the judiciary would fundamentally and constitutionally have more powers than the other branches of the government, and thereby undermine constitutional supremacy, and of course parliamentary democracy, which is of course sacrosanct. Right? Now, apart from this, we also understand that the president always has to act on the aid and advice on the Council of Ministers. So therefore, the government does end up playing a role in the appointment of the judges. And for example, the K.M. Joseph case and the Krishna Bhatt case, wherein a sessions judge had to be elevated to the High Court. You don't need to know the technical details of it. This is more than enough. And while all of this happens, even if you give the judiciary slightly upper hand when it comes to appointments, but in terms of removals, it is the entire process resting with the parliament. Although we've not had a single removal of a Supreme Court or even a High Court judge in the country, we've gone very, very close. We've had proceedings, but either the judges have resigned or the judges have already been retired. Now, you must understand, when you are impeaching a judge, that does not mean that you're sending the judge to jail. It does not mean that you're imposing a fine on the judge. What is up with you guys asking questions in the middle of the class? Yeah, have you forgotten your manners in one day? Do you think this is a one-on-one tuition class? What is wrong with you guys? Anyways, so you have what is called, this entire process of checks and balances, right? It is not in your favor. The flow of thought gets broken. Then I'll only give you what is very basic to be done. So learn to behave yourself in class. You would not dare to do this, right? Okay. Prakhar, Aryan, Abhishek, Pushpendra, Azim. What is wrong with you guys? Are you guys privileged than the other bunch who's sitting quietly and listening to class? And if you have the time to type such a long message, don't you have the time to just, be quiet and read and understand and wait for your time to come? The next time you guys speak out of turn, I honestly will have you guys chucked out of class. Anyways, so this is the impact of it. It really spoils the tenor and the sort of flow of the class. Anyways, so the process, of course, lies entirely with the parliament. Now, where are the problems and why does India have such a process? See, the primary problem is that the judiciary appoints itself, which means while I understand that the judiciary is the one who is making a decision entirely on the basis of who gets to become a Supreme Court or a High Court judge, but because there is no formal process of inclusive participation, of taking the views of the people, it is exactly this process which was abused during the emergency, and we had extremely pro-government Supreme Court judges. There is absolutely no certainty that today all of the Supreme Court judges and all of the High Court judges are completely neutral, are completely independent of the government. This leads to lobbying, this leads to power brokering, this leads to an internal backdoor kind of a behind the curtains kind of a system, wherein you will still influence the process of lawmaking and the process of appointing of your judges. So there's of course a problem, which of course leads to a lack of transparency, objectivity, and accountability. And as a result, what happens is you've only given broad guidelines. You do not have technically, procedurally, very intrinsic set of guidelines that tell you that, this is the collegium, these are the grounds. You do not have any efficiency matrix. When you are recruiting a judge to the Supreme Court or the High Court, how do you know that a judge is a good judge? And a good way is to analyze the kind of judgments the judge has given, which is also why technology plays a very crucial role. Like, for example, if the judgment is so sound and if the reasoning and the application of the law and the consideration of arguments and the drafting of the judgment is so impeccable that the judgment, even if it goes on appeal, the appeal will not be entertained by a higher court. That shows the prowess of the judge. That shows the expertise and the goodness of a judge in terms of the work. How many times your cases have been adjourned, how many times your cases have gone in appeal, how many times your judgments have been overturned, how many pending cases have been there during your tenure as a lower judge, or so on and so forth. Or even as a lawyer, what are the kind of cases that you've argued, what is your general success sort of a ratio. And the word success is also slightly questionable in the legal system, because our legal system is built on an adversarial format. An adversarial format means there's always going to be a winner and a loser, and lawyer one is always going to be against lawyer two. But we must not forget that whether it's lawyer one or lawyer two, whether it is the prosecution or the defense or any of the other two sides, at the end of the day, both of these are lawyers of the court. They are officers of the court. And because they are officers of the court, they must, work in the interest of justice. But that's also an ethical problem, because on one hand, you have to do whatever it takes to ensure justice is ensured. And on the other hand, you also have to do whatever it takes to represent the best interest of your client, no matter how good or bad the client might be, no matter how guilty or innocent the client might be. You are there to represent somebody. You are there on behalf of somebody. So which is why you don't really have an assessment or a performance grading matrix in the country, which is why the whole process of appointment becomes slightly complex, becomes slightly difficult, right? Now, at the end of it, it is therefore an extremely detailed process of impeachment. When you have the Judges Inquiry Act and the committee has to be set up, the committee will give its report. This is not an instantaneous setup wherein within a month it's all done. A lot of times these impeachment proceedings can often take 2 sessions of the parliament, because there is no time limit on the committee also to give its findings, because at the end of the day it is a quasi-judicial process and you can't put a time stamp on it, because if you do, then it goes against the principles of natural justice, which ensures everybody the right to a free and a fair trial. Now, while I understand that this is not a trial in a court of law, but you are kicking somebody out of their job. You're not sending them to jail, you're not giving them a fine. I understand that. You are removing them as a judge. I get that part. But that does not necessarily mean that the process has to be, so tedious. And if you draw an analogy, if there can be fast track courts for, rape cases, for corruption cases, then there could be fast track mechanisms, not courts, for an expeditious removal of judges, right? Now, apart from this, the president is, of course, the head of the state, appoints the judges. In reality, the president is bound by the Council of Ministers. So, whether you like it or not, if the government really has a problem with somebody becoming a Supreme Court or a High Court judge, they will make sure that the president, returns the recommendation back. And it could then become a cyclical process. Now, the question is, why does India tend to have, a process like this? There are basically 2 reasons. First is that you wanted to maintain a degree of separation of powers. Otherwise, if the judges of the Supreme Court and the High Court, especially the higher judiciary, were to be appointed in such a manner, it would, of course, take away the independence of it if they were to be appointed through a committee or through a consultative process. When the judiciary through itself internally is recruiting, they are relatively more free from external influence. And second, this also ensures that there's a good system of checks and balances. If you've been appointed rather independently or comparatively independently, then you will not have multiple rounds of hesitation. You will not have issues in striking a controversial law down, or taking an action which could be construed as a step against the government. So that is exactly why you need to have a process where the judiciary is kept separate, especially in a parliamentary democracy. Now, why especially in a parliamentary democracy? Because in the parliamentary democracy, the power ultimately rests with the parliament, and then as a subset of the parliament, you of course have your elected executive. Now, in a presidential system like the US, the president plays a very active role in the appointment of judges. And in the US, the judges are semi-elected in nature. That's not the case here. So you could say that in the US, it is far more clear as to what the stand and the ideology of judges are. But in India, it's far more opaque. And it's a very interesting point to make. With greater independence comes a greater illusion of knowledge, of information. We've made the process so independent that we really don't know much about the process. Very little is actually in the public domain, which is why there is, of course, the issue of reforming it. Now, what has been done to sort of make it better? One, this was, of course, to the National Judicial Appointments Commission in 2014. The NJAC Act was supposed to sort of make it better. We explained this before. And it was struck down in 2015 because of two reasons. First, they did not follow due procedure, which meant that they had to first amend Article 124 and then follow it up with an NJAC Act to give technical procedural details, like the Judicial Inquiry Act. So they instead passed the act first and then the constitutional amendment. The order should have been different, but this is just a procedural issue. Second is, of course, it was the more substantial reason was that it was violating, the independence of judiciary, which is, of course, basic structure. And as a result, they revived the collegium system, and then they said that we will inform the government in due time of eligibility, transparency. We'll have a proper collegium secretariat, we'll have a complaint system, we'll have an online disclosure. All of those things will definitely happen. Don't worry about it. And of course, very recently, in 2019, I think, the Chief Justice of India's office was brought under the RTI Act. Now, this means that the Chief Justice of India becomes a public authority, and for non-judicial issues, you can, of course, file an RTI to the Chief Justice of India. Now, the real question is, can I file an RTI to the Chief Justice of India asking the grounds and the process with which a specific judge was appointed to the Supreme Court? Well, there is no clear answer to this, and unfortunately, we've got to assume that the answer is no, because it comes to be a part of the judicial function, right? So these are basically the broad steps that have been taken by the government. Now, apart from this, what are your possible solutions that have been recommended otherwise? So the 14th Law Commission, very old, had recommended that every appointment to the High Court and the Supreme Court should be in the concurrence of the Chief Justice of India. The second was the 80th Law Commission report, which suggested 3 senior-most colleagues during the appointments. We are now doing that. The 121st Law Commission report had recommended that we should have a National Judicial Appointments Commission. Now, very interestingly, around this time, there was another bill that never saw the light of day. The bill was lapsed. We were supposed to have the Judicial Standards and Accountability Bill. The Judicial Standards and Accountability Bill was not about recruitment or transfer. The Judicial Standards and Accountability Bill was introduced in the Parliament to set up a dedicated committee wherein complaints against the judges could be entertained, could be looked into, and of course could be spoken of, right? And of course, that never saw the light. I'm writing the name here. the national judicial standards and accountability bill. This has been lapsed, and this was supposed to basically set up a committee for complaints against the judges. This does not exist, but if you can drop this name in your mains answers, you will certainly get a few points here or there. Then it was also recommended that we should have a high, in that the High Court's Arrears Committee in 1978 suggested that we must have, at least a 1 year or at least a 6 months time frame before you actually start doing so. It also recommended that if the recommendation is being made by the Chief Justice of the High Court, and if it's not dealt within 1 month of the date of receipt, then the state government should have deemed to have accepted the recommendation, and you should immediately, the center should take the process of recruitment. Now, that often does not happen, which is where the problem lies. Now, the National Commission to Review the Working of the Constitution had also recommended setting up the NJAC, but of course, this never happened. It never saw the light of day because it was struck down by the court. Even if you're able to write 2 or 3 out of these recommendations, you are in fairly good hands. You don't need to worry more about it. Okay, so this is your primary recommendations. Now, 2021 saw something very interesting. What 2021 saw was that in the history of this country, for the first time, we have the largest number of Supreme Court judges who are women. Now, you must also understand this at the same time, that while this makes sense, it still does not in any way show that we have enough women judges in the country. There has already been a question in the mains on this, and I had covered this before the mains also for a lot of other batches. So this is something that we got spot on. The recommendations basically are to ensure that you have that at the collegium level, you ensure that there is at least a woman judge, or you could at least make sure that a percentage of women are reserved for higher judiciary. So we'll come to that in a bit. So for the first time, there are actually 4 sitting women judges in the Supreme Court, and while the primary criteria for Supreme Court appointments has been seniority, a lot of people have argued that gender should also be a consideration. Now, I'll give you a little bit of data. We've got currently 650 High Court judges spread across, states and union territories. Out of the 650 High Court judges, we've got only 76 judges who are actually women. This means there are only 11.7% of the current judges of the 25 High Courts in the country. Now, this is a very, very disappointing figure, because half of the population of the country are women, and just 11% of all the judges are actually, yes, in its 72-year, this is not representative of the population of women in the country. Now, in its 71-year history, the Supreme Court has, of course, developed some sort of an unwritten criteria, a convention of it, which is, of course, not written anywhere in the Constitution. The most relevant of it, of course, is the principle of seniority, with the most senior judge of the High Court being preferred for appointments. Usually, Chief Justices are appointed to the Supreme Court. Chief Justices of the High Courts are elevated to the Supreme Court, which is why the average duration of a Supreme Court judge is also very, very low, which also means the average duration of a Chief Justice of the Supreme Court is also very, very low. Because if most of your Supreme Court judges are going to be sitting High Court judges, Chief Justices, that's around the age of 62. You'll have barely 3 years to be a Supreme Court judge till 65. which is why there is of course a tenure problem, right? Now, there are arguments here that say that these conditions do not of course take gender diversity into account, and that should be included at all given points of time, right? Now, in August 2021, three women judges were appointed to the Supreme Court. In fact, B.V. Nagratha is in fact going to hopefully becoming the first woman Chief Justice of India in 2027. She's going to be the first female Chief Justice of India in just a few years from now. It also understands that that this time in 2021, when women were being appointed to the Supreme Court, while seniority was a criteria, it was not the only criteria, because the only time seniority is a compulsory criteria is appointment of chief justices. But other judges can be appointed from a composite criteria as mentioned in the constitution. So it was very refreshing and heartening to know that gender was an important criteria in these rounds of appointments. Now you must understand this, that when you are appointing diverse judges, right, seniority has in fact been taken a little on the compromise. Like for example, Akhil Qureshi, who's the Chief Justice of the Tripura High Court, just as an example, is one of the senior most High Court judges in the country. He was not appointed to the Supreme Court at all, whereas Nagratha was 33rd in the High Court seniority list before she was actually elevated to the Supreme Court. So seniority as a concept primarily and only applies to Chief Justices, but not other judges. Appointment of Chief Justices, so to speak, right? Now, apart from this, when we look at it in terms of diversity, let's understand this as a whole. So when you look at judicial appointments on how meritorious they are, how transparent they are, how diverse they are, let's understand this. Yes. So since 1950, there have been about 247 Supreme Court judges till today, okay? And only 8 have been women. And today, 4 out of those 8 women are all together in 2021, which of course makes it an incredibly, amazing sort of a place to be in, right? Now, as of June, only 76 out of the 650 High Court judges were women, as I told you before. Now, Hima Kohli, who's the Telangana High Court, was the only woman Chief Justice. I think she's retired now. Now she's been appointed to the Supreme Court, which leaves the High Courts with 0 women High Court judges. There is not a single woman High Court Chief Justice across India. You have High Court judges who are women, but no Chief Justice of the High Court. Right now, of course, the higher judiciary, unfortunately, has not taken measures in which or through which you could ensure what was called gender diversity. Merit has always been the primary criteria, but the very definition of merit is not defined, is not accurate to begin with. And seniority of High Court judges has always been considered to be a proxy for merit in discussions regarding Supreme Court appointments. Now, what does this mean? This means that just because you're a senior in the Supreme Court, or if you're a senior in the High Court, or even a senior in the Supreme Court, seniority necessarily means that you're a better judge because you've seen more cases. That's not how it is. Maybe a more experienced doctor is always a better doctor, but we all know that more experienced doctors are more set in their own ways. Similarly, the more experienced your judge is, that does not necessarily mean that the judge is going to give an impeccable sort of a judgment, right? Now, when you look at the 14th, 79th and the 80th reports of the Law Commission, where of course, religion-based, political-based, any region considerations are also rejected. There were also Law Commission reports that said, if the Supreme Court is the national apex court of the country, then judges should come equally from all parts of the country. That's actually not the case. You'll see a large section of judges coming from one region of the country. That does not necessarily mean that all states or all regions of the country are equally represented in the Supreme Court. That does not happen. if there are 34 judges, it does not mean that there are, all states, or at least north, east, west, south, have about 5 judges, 6 judges, 7 judges each. That's not the case. It's not that there is some language or some regional criteria. In fact, the Supreme Court is always considered, unquestionably, of course, seniority as a convention of appointments. This is, of course, briefly a problem when Prime Minister Indira Gandhi had appointed Justice A.N. Ray, as I was telling you, in 1973 as the Chief Justice of India. The Chief Justice of India, Ray, as I told you, was appointed irrespective of the fact that there were 3 more judges who were senior to him. And of course, this was a shocking view. And of course, after the emergency, the Supreme Court prioritized seniority and said, boss, if we are appointing the Chief Justice of India, we're not going to get into this, which also means that this is actually very tricky. It's easy to simply stick to seniority because seniority is something which is absolute and can be quantified. Merit, on the other hand, cannot be quantified in the case of the judiciary to an absolute degree. So the chances of the executive overturning or returning a recommendation purely based on anything but seniority is higher than the president returning a recommendation purely based on seniority. And that's something you must understand. That is something you must understand. Okay. Now, however, when you are making an argument for seniority, you forget vulnerable sections such as women. In fact, it was only recently, about 8-9 years ago, that Justice K.G. Balakrishnan was the first, and I hate using the word dalit because it has a negative connotation to it, but was the first Dalit Chief Justice of India in the history of this country. Okay, there is otherwise no reservation applicable to Supreme Court or High Court appointments as such. Right now, of course, what is the impact of this is, if you want the judgments of the country, which play a very significant role in shaping the policy discourse of the country, which play a very significant role in shaping what direction is the country moving to, you need to have judges who are women in the Supreme Court, or in fact even in the High Court also, because this will lead to gender sensitive judgments. See, when a rape case, for example, is being decided by a male judge, while I understand that the male judge will very clearly and when properly apply the law, but the judge in the Supreme Court and the High Court not only applies the law, but also helps you to evolve the law. And you cannot evolve the law on rape, make it more strict, take into account all considerations, unless you have a woman judge who will have that perspective by the basic ability of the person being a woman. It's something very simple, right? It's like for example, National Commission for Women don't have any women members. Why does the National Commission of Women mostly have women members? It's because as a woman, they will be able to understand better than any man, beyond technical expertise, what are the real issues. So if it can apply to National Commission for Women, it can also apply here in this case, which of course is with respect to your judicial appointments, right? Now, there were certain recommendations that were also made that we should now have women-centric, minimum women representations in the collegium process also. Now, what is also very interesting to notice, India, of course, is the only constitutional democracy, as I told you, that we are a self-appointed one. And this, of course, leads to lack of transparency and accountability. And therefore, these discussions that happen, the decisions behind collegiums are, of course, not available to the public. Now, if you compare it internationally, and the South African Constitution provides for a Judicial Service Commission comprising of members of the judiciary, executive and legislature. And their constitution expressly provides that the judiciary should reflect the racial and the gender composition of the country, which means the judges in South Africa must come from all races and come from, of course, all genders. And this has, of course, radically changed the composition of the South African Supreme Court and other courts. Between 1994 to 2011, the number of women in the judiciary has increased from 9 to 61 in less than 20 years. So, this is an example that you can use in your exam. I don't think you'll have a question directly on women in judiciary anymore, but you can use this as arguments and larger answers of gender in an essay format, or say vulnerable sections, so to speak. Okay. Now, we now get into suo motu in the Supreme Court, in terms of how can they, really take cases without anybody being involved, without somebody filing the case. I'll give you a 5 minutes break. We'll start with Supreme Court and suo motu. In the meantime, I'll just quickly go through your questions also. Right, Prakhar. Absolutely. You are absolutely right. It wouldn't have violated it. No, there were other arguments also in terms of the appointment of eminent judges as well. Aryan, that's why you have national judicial academies and state judicial academies. It's the same thing as saying you first become qualify and become a civil servant. Then they'll train you how to be a civil servant. Okay, the criteria for lawyers is that I explained to you, Abhinav, that there's nothing called just a Supreme Court lawyer. Okay, the only people who only argue at the Supreme Court are people who are government lawyers, right? Center state. It's a convention. It is not mentioned in the Constitution. Yes, Nayub, bilkul. Aryan, I understand that, but this is the primary motive of the chat is to, while the class is going on, is to keep a check on any audio video issues. Yes, certainly, sure. Right. Okay. Gender is not mentioned, Amisha. With your name, I'll have a look immediately. Having judicial officer 10 years means, yes, it means you are a judge in a lower court. Tribunal members can be reappointed, yes. With the birth of basic structures, yes, we can. Absolutely. Fantastic. Center and UT will not be a dispute unless it's a UT with legislature, and there it depends on the kind of dispute, either the High Court of the UT or the Supreme Court. Yes, yes, Nishant, you absolutely can do that. Fantastic, absolutely. All right. So suo motu power is basically what usually happens is X files a case in the court against Y, and the court calls X and Y and hears the matter. When there is no X, the court, on the basis of a newspaper editorial or anything, just takes up a case and calls Y and says what is happening. This is what is usually called, suo motu. So let's understand what is suo motu and how does it work, right? Now, a suo motu power is actually granted by Section 23 of the Contempts of Court Act, wherein the Supreme Court has the powers to punish for its own contempt, and the High Court has the powers to punish for not only the contempt of the High Court but also of the lower courts. So in that sense, High Courts are contempt courts for not just the High Courts but the other lower courts within the state. Thereby, a more diverse range of courts are represented, in the High Courts, and we understand that. On the other hand, the Supreme Court primarily does only look at Supreme Court. Now, for example, in the contempt issue, the contempt is against the Supreme Court. So the Supreme Court will not fight. So if there's a contempt, for example, there's X who's tweeted something against the Supreme Court. So the Supreme Court will not file a case in the Supreme Court against X, right? So this is where the Supreme Court automatically takes it into account, and that's the origin of suo motu powers. That sometimes you don't need a person to come to you when the person is affected, which is you, and you're the one who's supposed to decide it, which of course is problematic in terms of conflict of interest. But well, nobody else is competent enough to do this. So you have contempt of court powers which originate from the Contempts of Court Act, and of course many other common law jurisdictions, UK, Canada, Australia, all of them also have similar powers. However, the use of this procedure in terms to issue writs or judicial review has been extremely novel to India. It is something that largely happens in India, not anywhere else in the world to this degree. US is not a common law jurisdiction, so it also happens in the US to a large degree because of due process of law, which is explicitly mentioned in the US Constitution. So what happens is that in most countries, courts have suo motu contempt powers. But in India, not only do you have suo motu powers for contempt, but you also have suo motu powers for judicial review, right? Or, issuing a certain set of writs. And courts often exercise their suo motu powers by taking up matters based on media reports or letters which are written to the Supreme Court. Several cases, right? Now, Articles 32 and 226 confer on the Supreme Court and the High Courts wider constitutional and public law powers. So these suo motu powers exist not only for the Supreme Court but also for the High Courts also. Now, these powers have been interpreted to take up cases on their own violation. Okay. Now, this basically means that you don't need a formal petition to be filed to be sent to the register of the court, and so on and so forth. And therefore, suo motu powers have historically developed contemporaneously with public interest litigation, where procedural requirements were sort of relaxed in the interest of justice, right? To ensure basically that you're able to have a more functional ecosystem, you're able to have a more vibrant sort of an ecosystem. Okay. Now, And the other reason is, for example, if most people don't come and report a crime, imagine most people will not want to go to a court, because this is a very tedious process, a very complex process, a very time consuming process, and also an incredibly expensive process, which is why it's extremely important for the courts sometimes to take matters into their own hands. Now, does this violate the basic principles of separation of powers? If you're using it the wrong way, if you're rubbing it the wrong way, arguably, yes, it does. It most certainly does. Right? Now, when we look at some examples, when we look at issues which have been taken on media reports, for example, in Sunil Batra versus Delhi administration, wherein I had spoken to you about how the judicial side to judiciary is state, the Supreme Court actually took up the matter written to a judge about the torture of prisoners and the violation of prisoner rights and the fundamental rights which are also there for prisoners. I understand they can't vote, but they have all other fundamental rights. They've also been used widely to tackle environmental issues such as air pollution in Delhi, such as, of course, remediation of polluted rivers. In fact, not only the Supreme Court and the High Court, the National Green Tribunal, and you'll find this in the notes also, we've discussed this, the National Green Tribunal also exercises a lot of suo motu powers. Now, I understand that the basic perception in the media is that the Supreme Court is just using suo motu left, right, and center. That's actually not the case. That's actually not the case. In the history of this country, right, there are very, very few suo motu cases. So, for example, since 1990, right, post LPG, there have been not more than 50 suo motu cases. And they mostly deal with human rights or larger issues of government policy. Several cases have no doubt been criticized for allowing the courts to undertake sort of heroic interventions, and they often infringe upon the powers of the legislature and the executive. I understand that part. But it does not mean that it is a very heavily relied upon mechanism, right? Media support and public applause, of course, is greatly appreciated. A lot of times it makes the Supreme Court or the High Courts, but mostly the Supreme Courts, the knights of the shining armor. They become the ultimate saviors, and you look at sort of immediate solutions and effectiveness, and of course all of those things are there. But like earlier in 2021, you saw that the courts had actually used their suo motu powers to hear COVID-related issues. There was COVID litigation where you would remember the Supreme Court literally pulled up the government and asked the government extremely tough questions. What is it that you're doing for oxygen management? Have the oxygen centers been established? Why are the states or the hospitals not getting oxygen, right? And therefore, these related orders effectively compelled the union to eventually draft a policy, change their crisis management method. Judicial intervention was largely welcomed because there was, of course, a degree of executive inaction. So a committee had to be set up, and all of those things were also to be done. So there are some good things about it. The most recent example, in fact, there was only one suo motu case all of 2021 in the Supreme Court, which was the COVID litigation case. Otherwise, the Supreme Court did not take up anything else suo motu all of 2021. Now, it then sort of makes us to understand what is the contempt of court. See, we understood that contempt of court previously is also a reasonable restriction under Article 19, Clause 1, Clause A, that you have the freedom of speech and expression, but your freedom of speech and expression ends when you are trying to say something scandalous against the court. So this is nothing but showing disrespect or undermining the dignity of the authority of the court. And as a concept, contempt of court proposes to protect judicial institutions from motivated attacks, from political action, from any form of resentment which is not genuine in nature. And it is, of course, used as a legal mechanism to punish those who are, lowering its authority in order to safeguard the interests of the people and sort of and obstruct the administration of justice. Now, as I've told you, the Supreme Court and the High Court derive their powers from the Constitution, and the powers are under Articles 129 and 215, wherein the Supreme Court has a power of contempt over itself, and high courts, of course, all other courts, including the High Court. And then you have the 1971 Act. Now, very recently, in the December 2021 winter session, there was a private member constitutional amendment bill, which was introduced, which was laid in the houses in the Rajya Sabha, where they wanted to add specific ingredients of contempt, but that, of course, was not taken up in the last session, and I don't think it's also being taken up in the budget session. Now, the Contempts of Courts Act 1971 is actually the primary legislation which gets into the technical details of it, right? Now, the High Courts, according to this Act, also get the powers to punish courts under them. The Supreme Court, of course, for themselves, of course. Now, apart from this, certain administrative tribunals, such as the Central Administrative Tribunal, they've also been given certain powers for punishing of contempt. Right? Now, the Contempt of Courts Act of 1971 outlines the procedure in relation to investigation and punishment of contempt. Now, according to this Act, contempt is divided into civil and criminal contempt. Very simply, if you don't follow a court order, it's civil contempt. If you say anything against the judge or the court which is degrading in nature, that's criminal contempt. So, civil contempt can be usually with a fine. Criminal contempt could be with fine and jail. That's the difference. Now, the Act provides that this could be brought against a judge or a magistrate or any person acting judicially for contempt of their own court, and of course will be applicable to anybody, including the judge. Now, this is something you must understand. Who can commit contempt? Could be any person, and sometimes the judge himself or herself can commit contempt against the court. So there could be actually provisions where the judge could be charged with contempt. What if the judge said something, or, for example, let us say the judge's children case came to the judge's court and the judge did not recuse herself or himself from the case. That actually is contempt. You're supposed to recuse. You can't be a judge in the same court as your children are arguing. Like, for example, what's very interesting was Justice Rohinton Nariman, right, who recently retired as a Supreme Court judge, one of India's most well-read judges, in my opinion, and an authority on law, literature, and religious jurisprudence. But anyways, his father, Fali Nariman, who was also a law minister at a point of time, his father, Fali Nariman, was in fact was a lawyer, right? Has been a lawyer. Now, the father could not argue in the son's court at the Supreme Court, right? To give you a little bit of context, his father is in fact written a fantastic book called Before Memory Fades. It's an autobiography of Fali Nariman. Good book. Don't read it now because you have your syllabus to go through, but later in life, whenever you have some time, you should certainly, read this book. Now, when we look at contempt of court, we have a very simple, broad kind of an idea around it. See, contempt of court is of two types: civil contempt and criminal contempt. As I said, civil contempt is not following the orders of the court, and criminal contempt is by speech or by text, you're scandalizing the court, you're interfering in a judicial process, or you're interfering in the administration of justice as such. Like, for example, you're not letting a court summon being delivered to somebody. That's obstruction of justice. Now, it's been in the news primarily because of the Prashant Bhushan case, where he had basically tweeted twice with regards to how the court functions and how the Chief Justice of India, Justice Bobde, the previous one, was basically on a bike and was held to be in contempt of court, and symbolically, ₹1 was imposed as a fine. Now, the scandalizing of the court broadly refers to statements which make, which are insulting to the office of the court. And the punishment of the contempt is very simple, and it goes from about 6 months to about 2,000 rupees. So he could have either gone to 6 months of jail or a fine up to 2,000, but symbolically, just ₹1. But Prashant Bhushan was convicted of contempt of court. That's the important part. right? So he has a criminal conviction against him. Okay, understood this, right? Now, very specifically, what is not contempt of court? That's also extremely important. If you're fairly and accurately reporting judicial proceedings, like for example, when the Supreme Court had struck down NJAC, there were a series of editorials in the newspaper, which criticized the Supreme Court left, right, and center. That's all right. You have the fair rights to criticize the merits of an order after the case is being heard of and completely disposed, which is why you would have often heard of a word called sub judice, which means that if the case is currently pending, you cannot make any public statement about it which influences the case or the judges for that matter. And initially what was the case was that this is also true for defamation, that if, for example, I say X is a bad person, and if the truth is that X is a bad person, I am basically saying the truth. So why are you penalizing me for saying the truth? So initially, truth was never a defense in a contempt case, but an amendment in 2006 said that what you're saying, if it is true, then yes. But in the case of Prashant Bhushan, basically the Chief Justice was on a motorcycle. So he linked the motorcycle, which was belonging to a BJP person, to how there is a collusion between the judiciary and the government. Now, there is no truth here, because truth has to be absolute, truth has to be proven, truth has to be impeccable. That was really not the case here. Okay, understood? Now, apart from that, there are certain arguments which say that yes, contempt of court should exist. There are certain arguments that they said that they shouldn't. The first, of course, is that there are issues where the dignity of the court gets compromised. You have to maintain the competence of the court. You have to maintain the integrity and the placement of the court. If the parliament has the powers for privileges, then the judiciary should have the powers for contempt. Second, at the end of the day, this is constitutionally originated. That's what the makers of the constitution originally wanted. And third, if not at the higher courts, but at the lower courts, where justice and administration of justice is an issue, summons are not received, people don't show up, tampering of evidence happens, influencing witnesses happens. All of these things, in fact, are obstructing justice, right? So they have a lot of impact on subordinate courts. And then, of course, is that a very clear if you sort of change the definition of contempt, it will of course lead to ambiguity, and therefore you may have multiple definitions, there'll be multiple judgments on it. And if the Supreme Court is giving you a judgment on contempt, then this is also, you deciding how much marks would you be getting in the mains exam, right? And of course, what should be done is what the Law Commission said, that there should be several safeguards. They should not be used in an abusive manner. And that is why there are very clear reasons in the law itself that say that this is not contempt. Like how a fair and assessment report of the court or a criticism of a judicial order, that's not contempt at all. Okay. And there are, of course, equally important arguments against contempt of court. The arguments that are there against contempt of court are that, of course, this is in conflict. Right. So this is, of course, in conflict with freedom of speech. This can, of course, lead to people not saying what they want to, because they might just be facing a criminal charge. And Justice Krishna Iyer, who's always been a very anti-contempt law judge, often said that this can be vague, this could not necessarily be for public good. Second is, almost everything under the sun is contempt. And third is, truth and good faith defenses are barely ever entertained. Now, while I understand that, yes, truth is a fantastic defense and it should always be the case. And I understand that this truth as a concept must be used under all circumstances, but nobody really cares about the truth. Because what you are saying is that, I'm saying what is right, the judge is wrong, the court is wrong, but there's no objective way to use it, and they will never be really taken up in a court. Now, if you see this internationally, England abolished the offense of scandalizing the court in 2013. Canada says that unless there is a real or a tangible danger to the administration, it will not be a contempt of court. And America also says that we don't longer use the contempt of law court unless if it's a response to judges or how they've delivered judgments. That's something that we don't entertain. You have the right to, if you have the right to criticize the government without any bars attached, you should also have the right to criticize the courts without any bars attached. So that's something that is true. That is something that must exist, right? So what is your primary conclusion when it comes to contempt? The Law Commission has looked into this and said that, boss, this should be retained, but it should also be used, contempt, death penalty, everything should be used in a rare to rare cases, and therefore the contempt should be restricted only to civil contempt. Don't sell anybody to jail just because they've disagreed with you or they've said something which hurts you. Sending somebody to jail can potentially, have a non-returnable impact on their lives. Okay, now this is not. You don't get questions on pendency as such. You've never gotten a question that says, why are cases pending in the court? There are 10 other reasons, but the point is I wanted to give you some data. Now, this data I will update before your mains exam also, but I'll just give you data of 2021. So in 2021, we've seen about almost a 7% increase in Supreme Court pendency. Currently, you have about 70,000 cases which are pending in the Supreme Court. And totally, there are about 3.5 crore cases which are pending in the judicial system, and this is official judicial information system data, right? And 88% of these cases are in the lower judiciary. This is where the real problem lies, which is why All India Judicial Services, which I will discuss now, is sort of important. It's nothing but changing how lower judges are being appointed. Written exam by the government, interview by the High Court panel, basically have an All India exam. Right now, and more than 64% of the cases have been pending for more than a year. Now, of course, when you look at the ease of doing business report, which of course has been a problem and has been recalled, but if you look at the ease of doing business report from 2018 and 2019, you will see that the average time taken for a case to be settled is 1,445 days. Right, that's a lot of time. Right, that's approximately 5 years, and consistent increase in the pendency of cases and has been on the rise, and highest number of cases which have been pending is of course Uttar Pradesh. And as we know that the number of and as a consequence of this, because the cases don't get decided on time, the number of under trials in prisoners are more than double than that of convicts, which is what I told you, that more than, if there are X number of people who've been declared guilty, there are actually 2x number of people whose cases are still going on and they're still as under trials in Indian courts. Okay, now, pendency. Why does this happen? And I like images, so I thought I'll put some. So first, of course, is you are now seeing more people come to court. Two, you now see newer mechanisms which have simplified judicial cognizance like PILs, right to information. Then the government denies it and then you challenge it in the court eventually. There's of course higher vacancies in the judicial system. And not only this, there are of course insufficient number of courts. And beyond the insufficient number of courts, you will see increased litigation from the government. There are of course several issues. Sorry. Right. So there are several issues with litigation from the government. There's of course a current affairs issue, which is that the Vodafone case, and continually more and more cases keep coming in. There's poor judicial quality, so people end up going on appeal and appeal and appeal. There are of course old laws which are very vague and you require interpretation, so more and more cases keep coming in. There are no strict timelines. There are repeated adjournments, which is come another day. This gentleman here is known for this. Okay, these are the reasons why pendencies happen. Now, as a result of this, under trials are suffering, economic issues are there because as a result of which, when your justice is delayed, right, business disputes get delayed. So when business disputes get delayed, business actions get delayed, foreign investors hesitate to invest in India, which affects Make in India. Judiciary becomes overburdened, which means it's like you have to finish your entire syllabus in 1 month. You will not be able to do it efficiently and productively. It erodes the social infrastructure, which means the whole rule of law, respect of law argument goes off. Then, of course, your prisons get overcrowded. They become COVID hotspots, right? There's, of course, a financial drain because you have to spend so much money and on upkeep of prisoners, upkeep of prisons, costs of the court, and these judicial delays lead to delayed business contracts, I was telling you, which cost India 1.5% of its GDP, and therefore high time, energy, and money is of course very burdening for the common man. If you're ending up spending 10 lakhs on a property which is worth 5 lakhs, you will lose all possible faith in the interest of the judiciary, right? So what is it that should have been done? Have time limits, increase the number of judges, decentralize the working of the Supreme Court by having regional benches, which was something which has been going on for quite some time. So this basically means that the Supreme Court is in Delhi, I understand that, but it does not mean it has to only be in Delhi. So have 4 regional Supreme Courts: Supreme Court Delhi, Bombay, Chennai, and Calcutta. These Supreme Courts will be called final courts of appeal. So all cases from high courts of the West, South, East, and North will go to their respective Supreme Courts. And in Delhi, you will also have a Constitutional Court of India, a separate court which will only look into the validity of laws. So when you're able to do something like this, it will work out extremely efficiently. Okay, understood, right? Now, Justice Kapadia, law commissions, a lot of them have recommended this. Of course, increase the working hours, increase ADR, establish tribunals, fast track courts, have the All India Judicial Service, better case and court management, and of course, implement the National Judicial Data Grid so that you exactly know how many cases are pending where, and of course, to what extent and in what capacity. So these are some of the examples that you can write, some solutions that you can write. Okay. And that's how it is. Now, IT and judiciary is extremely important. Just very dedicated examples that you can use in e-governance also. So digitize your court registry, have e-filing, video conferences like in the pandemic, digitize court databases such as kaun sa case kab aayega, have real-time messages sent to lawyers and clients and petitioners, and have virtual proceedings whether there is a pandemic or not. Supreme Court is now partially starting physical hearings, but of course, right? And the Malibat committee said you should have more courts and judges. You should reduce your period of vacations by 21 days. Supreme Court is one of the few courts in the world which has a summer vacation, has a winter vacation, has a Diwali vacation, has a Holi vacation. Yeah. Now, of course, have something called an arrears eradication scheme where you can, send it to ADRs such as Lok Adalats. We'll cover ADRs eventually, but that's the larger point. ठीक है, मतलब ये बहुत सिंपल है, मतलब ये टक 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 इसको बस पता होना चाहिए क्या है, इसको फिर आगे निकाला, इसको कोई एनालिसिस नहीं है, बस इसमें समझना है कि ऐसा है तो क्यों है, नहीं है तो क्यों नहीं है, बिकॉज द क्वेश्चंस आर वेरी डायरेक्ट, वेरी स्ट्रेट फॉरवर्ड. ठीक है. नाउ अभी तक किया क्या है? We've implemented something called Justice, which is Just IS, Justice Information Systems, wherein you can now have a real-time tracking of your cases. That's extremely important. 2, fast-track mode of courts, wherein you have plea bargaining, where you say, अच्छा मेरे से गलती हो गई, मैं मान रहा हूँ मेरे से गलती होगी, मैं आपका टाइम बचा रहा हूँ, मेरे को 10 साल की जगह 5 साल के लिए जेल भेज दो. ठीक है. The legality around pre-bargaining is very complex. This is not an optional class. You don't have to worry about it. Sometimes for under trial prisoners, you can have temporary courts set up in the jail itself. Fast track courts for faster distributions. A campaign mode essentially to reduce pendency resolution, which happened in 2011. Ki tuck, 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 tuck. And resolution for prioritization of cases. For example, if there's a case which is extremely urgent, कि वो भाई मर जाएगा या उसका कोई मतलब बहुत मेजर प्रॉपर्टी का इशू है, डिवोर्स का इशू है, ऑल ऑफ दोस थिंग्स, In Hussain and other versus Union of India, the Supreme Court said you should have timelines of criminal trials. वो भी implement नहीं किया है. कहा था हाई कोर्ट्स को मॉनिटर करने के लिए, हाई कोर्ट ने भी नहीं इम्प्लीमेंट किया है. राइट, ऑफ कोर्स यू हैव टू मेक श्योर दैट अननेसेसरी को तारीख पर तारीख कि हम नहीं थे, वकील साहब को शादी में जाना था, वकील साहब की शादी हो रही थी, ये सब ड्रामे में आप केसेस में तारीख पर तारीख मत करो. Right, so these are things which are largely important and have also been taken into account. ठीक है. Now comes the last part, all India Judicial Services. It is nothing but replacing lower judiciary. ठीक है. 10 साल से ड्रामा चल रहा है, अभी तक किसी ने कुछ भी नहीं किया है इसमें. ठीक है, 10 साल से ड्रामा चल रहा है. So the first AIGS proposed by the 14th Law Commission was in 1958. Okay, the recommendation was to have a centralized cadre of district judges. Now, of course, today state service commissions and high courts collectively recruit lower judicial officers. And Law Commission ने भी बोला था कि भाई बहुत डिले हो रहा है, करके देख लो. In 1992 in the All India Judges Association, सेंटर को बोला था एक All India Judicial Association बनाओ. A year later, the court said, ठीक है, जब पार्लियामेंट का मन करे तब करना. In 2006, the Parliamentary Standing Committee, in its 15th report, said we should have an All India Judicial Service. In 2017, the Supreme Court said that, boss, ये जल्दी से शुरू करो, we should have a central selection mechanism. Right? Yes, thank you, Syed. बस इतना ही आसान है यार. हम बोल रहे हैं कि हम बेसिकली जुडिशरी का स्टेट सर्विसेज बंद करना है बाबा. जुडिशरी का स्टेट सर्विसेज बंद करना है बस, और कुछ नहीं है. अब उसके आर्ग्यूमेंट्स फॉर एंड अगेंस्ट वही है. इसलिए यूपीएससी कभी मेंस में डायरेक्ट क्वेश्चन नहीं पूछता, बिकॉज या तो कर लो या तो मत करो. राइट, वाई इज इट रिक्वायर्ड? इट इज रिक्वायर्ड बिकॉज लोअर जुडिशरी में रिक्रूटमेंट स्टेट वाइज होता है, बहुत वैकेंसी रहती है, रिक्रूटमेंट होता है, 2 साल बाद ट्रेनिंग होती है, 4 साल बाद अपॉइंटमेंट होता है, इट्स वेरी डिलेड, एंड ऑफ कोर्स यू डोंट गेट द बेस्ट ऑफ टैलेंट. Right, today IIT, IIM, DU chaps, Bombay University chaps, Calcutta University chaps, Madras University chaps, everybody appears for UPSC, है ना? Because national exam यहाँ नहीं है. So this was in 1950s. 312 में provision था through a 42nd amendment, उसको हमने implement नहीं किया. नीति आयोग ने इंडिया 75 में भी बोला था कि भाई कर लो, किसी ने किया नहीं. ठीक है, न्यूज़ में क्यों रहा है? क्योंकि ये ड्राफ्ट बिल इंट्रोड्यूस होना था, अभी तक नहीं हुआ. 2019 में तो तबाही ही मची हुई थी. एवरी यूपीएससी वीडियो वाज टॉकिंग अबाउट दिस. एग्जाम में बिल्कुल नहीं आया. दैट यू शुड हैव अ कंसल्टेटिव प्रोसेस. देयर आर ओनली 4 स्टेट्स एंड 2 हाई कोर्ट्स व्हिच हैड ओरिजिनली सपोर्टेड इट. स्टेट्स ने बोला अरे ऐसे कैसे चलेगा, वही कोचिंग हो जाएगी, लोगों को पैसा देना पड़ेगा. व्हिच आई एग्री. कोचिंग इज द वर्स्ट थिंग दैट कैन हैपन टू एजुकेशन. माई प्रॉब्लम विद कोचिंग इज नॉट द आइडिया ऑफ कोचिंग. प्रॉब्लम is how expensive sometimes coaching gets, है ना? And recently 2021 the center took the ordinance route to effect changes in the appointment of members to various tribunals, and of course many were abolished. So this of course has been why All India Judicial Services is an issue. अगर हमारे पास AIJS के ऑफिसर्स होते तो क्या पता हम उनको ट्राइब्यूनल्स में भी डिप्यूट कर देते, तो ये जो सेंटर को इशू होता कि भाई जजेस हमारे ऊपर आके नाच रहे हैं, वो भी शायद नहीं होता. Right, and then finally you have some arguments. You have some arguments for and against it. There are provisions which says 233 होना चाहिए. 42nd amendment में add करा था कि you can have all India judicial services, but this should not be above. This should not be a post below a district judge. मतलब सिर्फ district judge के recruitment के लिए. Then later on they said district judge and below भी कर लेंगे. A significant change was also brought in the 7th schedule, where NT3 of list 2 was entirely placed in the concurrent list, which of course was done through the 42nd amendment, which is basically administration of justice, organization of courts, except Supreme Court and High Court judge. मतलब आज 76 के बाद सेंटर और स्टेट्स दोनों इस पर कानून बना सकता है, नहीं तो सेंटर नहीं बना सकता था. राइट, समथिंग एज सिंपल एज दिस. राइट, नाउ ओरिजिनली 233 कहता है कि जो लोअर जजेस हैं वो गवर्नर स्टेट हाई कोर्ट की कंसल्टेशन पे करेगा, लेकिन 42nd अमेंडमेंट के बाद हमने सेंटर और स्टेट दोनों को ये पावर्स दे दिए, बेसिकली मीन्स सेंटर को पावर दे दिए. ठीक है, द प्राइमरी आर्ग्यूमेंट्स आर इट हेल्प्स टू सॉल्व रिप्रेजेंटेशन प्रॉब्लम्स. राइट, you have most reservation policies in place. You have a roster based reservation policy 69% in Tamil Nadu, where 30% are women. States like UP can immensely benefit where there is just 20% reservation. तो अगर आप जुडिशियल सर्विस रखोगे तो reservation होगा, because it's a government recruited service. So you'll have more women in the lower judiciary pool. So you'll have perhaps more women in the higher judiciary pool, and perhaps you will have more women at the Supreme Court. So it's a cyclical sort of a process. ठीक है. Then of course there'll be transparency, there'll be more efficiency, pendency solve होगी, corruption नहीं होगा, बड़े अच्छे अच्छे colleges के लोग आएंगे, you'll have better qualified judges, there'll be public faith in the judiciary, be favored by various eminent bodies, such as the law commissions, the chief justices. Supreme Courts have always given judgments in favor of it. The court has accepted most of the recommendations कि हाँ states को consult करके करो. So the stage is set. अब कर क्यों नहीं रहे हैं मुझे नहीं पता, वो इसलिए नहीं कर रहे. देखो, एक तरफ कहते हो कि गवर्नर करेगा, दूसरी तरफ कहते हो कि भाई सेंटर करेगा, एंड दिस इज इन्फ्रिंजिंग अपॉन फेडरलिज्म. Second, this may lead to a conflict of issue between the center and the states, because the power to recruit judicial officers far rests with the states, and it takes away the power of the states and the high courts to appoint and sort of administer high court subordinate judges. और दूसरा, तुम ऑल इंडिया पे कैसे कर रहे हो भाई? ऑल इंडिया पे कैसे कर रहे हो? हर स्टेट की अपनी लैंग्वेज है, जजमेंट में लोग अपने हिसाब से आर्ग्यू करते हैं, राइट? सो दैट्स ऑफ कोर्स एन इशू. ठीक है. थर्ड ऑफ कोर्स इज लोकल लैंग्वेजेस है, लैंड लॉस के केसेस होते हैं, तुमको लोकल डॉक्यूमेंट्स नहीं पढ़ने आएंगे, आईएएस बन के जाते हो तब इंटरप्रेटर रखना पड़ता है, आधे लोग सीखते नहीं है दूसरी स्टेट की लैंग्वेज, तो ये इशू है. एंड यू आर अज्यूमिंग दैट लीगल एजुकेशन इन इंडिया इज गुड. नो, इट इज नॉट गुड. मोस्ट लीगल एजुकेशन इज नॉट गुड. देयर आर अ फ्यू लॉ कॉलेजेस व्हिच आई अंडरस्टैंड आर वेरी गुड, एंड आई मे बी privileged to have attended some of those. I get that, but mostly the standard of legal education in India is very poor. The average law college and the average engineering college. The average engineering college is here. The average law college is here. Okay? तो इतना gap है. ठीक है. Now, apart from this, of course, it will be very difficult because coaching हो जाएगी, competition बढ़ जाएगा, and currently the judges of subordinate court who are appointed by the governor in consultation of the High Court will not be the case, because if AIGS is implemented, and this could violate independence of judiciary, कि भाई एक तो फेडरलिज्म पे क्वेश्चन मार्क है, बेसिक स्ट्रक्चर पे क्वेश्चन मार्क है, इंडिपेंडेंस ऑफ जुडिशरी पे क्वेश्चन मार्क है. ठीक है. एंड और ऐसा तो नहीं है ना कि मतलब ये होने से गारंटी है कि things will be better, which is why you need to have a concluding statement on this, that although it is supposed to be solving an issue of judicial vacancies, but पहले ये तो समझो कि ऐसा हो क्यों रहा है, right? And what a judicial service is after is set up, you should have a proper training ecosystem like you have for your civil services, and no doubt a merit-based judiciary is an absolute need of the hour, no doubt. But the efficacy of the AIGS will depend on its potential to efficiently address existing issues. ठीक है. बस इसके ऊपर ना जुडिशरी में आज तक कुछ आया है, ना कभी आएगा. आप प्रीवियस ईयर के क्वेश्चंस मैप करके देख लो, एंड दैट इज प्रीटी मच इट. बस समझ में आया कि जुडिशरी कितना आसान है. द टफ पार्ट इज जुडिशियल रिव्यू एंड एक्टिविज्म, जो हमने सेपरेशन ऑफ पावर्स में करा था. ये तो बहुत आसान है कि जज जजमेंट नहीं दे रहा, वकील वकालत नहीं कर रहा, और सब महंगा हो रखा है. मतलब बेसिकली इट्स अ सिंपल रेटोरिकल आर्ग्यूमेंट. ठीक है. डन. We'll do ADR and set the state relations tomorrow. So I'll see you. Bye bye.